And good morning, everyone. Um, Thank you all for joining me here this morning. It's so great to be back presenting to Peel Halton Workforce Development Group. As I'm sure many of you know, I've been speaking here, year over year, presenting on various topics for a number of years now, and I'm really thrilled to be back. Thank you to Angelica and Cellini for inviting me back again. And I'll just note as a personal note as well, my father-in-law, Jonathan Marler, who lived and worked in Oakville, he used to attend these as well. He was a subscriber to the content from Peel Halton, and he actually passed earlier this year. So I'm missing him here this morning, and I just wanted to make note of that for all of you. So without further ado, let me dive in. We've got lots to cover. Realistically, not enough time. Not enough time to cover all the big developments this year in the hour that we have, but we're gonna cover what we can, and I've tried to really just identify the biggest developments for you to be mindful of as you finish off the year and get ready for next year with all the legal issues that you need to face as an employer. So thanks again to Angelica for the introduction. As she said, I'm a labor and employment lawyer. My firm is actually based in Markham and I live in Toronto, but I have lots of connections to Halton specifically. I grew up in Oakville, and my mother and mother-in-law both still live there, and I'm there frequently, and I'm just thrilled to be here with all of you. So let's dive into our agenda for the morning. I've identified 5 areas where I think the developments are going to be most important for us to discuss before we shift away to some questions at the end. So I'm going to kick us off with legislative updates. There are repeatedly every year, oftentimes a couple times a year, like we've seen this year, big legislative updates for Ontario employers. This has been happening now for a few years. The Ford Conservative government has really been active in making changes to the laws for employers and employees in Ontario, and this year has been no exception. So I'm going to talk about just a few of the big developments there. I'm also going to speak about termination clauses and the legal enforceability of those. If you're not familiar with what I'm referring to there, I'll give you a little bit more context when we get to that section. But this is a hot topic in employment law and has been for a long time. Frankly, I wish we didn't have to keep on talking about these, but the courts keep changing the laws, and it's important that you're aware of those changes. And so we'll touch on those as well. From there, I'm going to speak about bad faith conduct. So when we're talking about employees being let go, the main thing we typically talk about are their termination entitlements. That's where those termination provisions that I'll speak about really kick in. In addition to that, though, employers also need to be aware of and wary of the potential for additional costs that come from employees being able to convince a court that they were not treated in good faith when their employment was terminated. And so we had a couple new cases this year that address that concept some more. And so I want to make sure we touch on that as well. As you're all, hopefully not facing terminations next year, but you never know what might come in a year. And so it's good to be prepared. From there, I'm going to talk about some big cases this year around human rights and accommodation. So really important things for you to understand when it comes to disability accommodation as an employer. This is a topic that is as hot as any. Disability management is really, a major issue for employers these days. It has been for a long time, but it's becoming increasingly so, where, employees are much more open than they ever have been before to request accommodations, based on disabilities, in part because, mental health issues that used to be very stigmatized, and a lot of people wouldn't request accommodations in that way, and they still are somewhat stigmatized, but certainly less so year over year. And that's leading to employees being more willing to ask for the accommodations that they need to be able to do their best work. And then as an employer, that brings up your obligations under the Human Rights Code to accommodate. And so it's important to understand, the scope of those obligations. And then beyond that, employees are also requesting more accommodations because, the reality is the workforce that we have today, and the kind of generational changes that we're seeing, employees are expecting more from their employers. They're less willing than in years and decades past to just kind of accept what the working conditions are set by the employer and do their job. They're expecting that the work, works better for them. And what we see from that is, again, more accommodation requests, whether they're, valid requests or not, and they're expecting more from the employer. So I'll be speaking a little bit about that. And then I'm going to finally end with workplace investigations, and specifically, where the duty is engaged as an employer to conduct workplace investigations, and especially when it involves off-duty conduct. This is another hot topic that we're seeing more and more of, where the lines between what is work-related and what is not work-related are becoming more and more blurred, especially with remote work, and employees kind of working at different hours than the old 9 to 5 that used to be a lot more typical. And so with that, the kind of where your obligations to investigate might kick in is not quite as clear. And so there's some cases to help add some clarity to that line for you, so you can understand it. And so we'll discuss those, and then again, we're gonna end with a Q&A. If possible, I'm going to see if I can just touch on a couple of other developments very quickly at the end, just to get them on your radar. But I'll say no promises on that one, because there's a lot of other important content that we're going to be covering first. So, starting again with legislative updates, what could be a sexier topic to start off your morning here than legislative updates? I know that may not be the most thrilling, but in all seriousness, this is really an important thing for you to understand. And this year has really been an important one. There have been two major bills tabled for employers, along with another bill that's come into effect this year from the provincial government of Ontario. And so if you don't know about these changes, you're going to get dinged. Like I was saying in the intro, employees, they understand their rights now more than they ever have before. There are other lawyers who do what I do, labor and employment lawyers. I act for employers primarily, but there's those who act for employees who are on TV, on the radio. I'm not going to name names, but I'm sure some of these, in the newspaper, and they're out there trying to kind of get attention, and in part that's resulting in employees having a better idea of what their rights might be. In some cases, that leads to employees not having a clear understanding of their rights, which unfortunately for the employer, that then becomes more complicated for you, because they're expecting things that might not actually be entitled to. But they are certainly aware more generally where they might have rights than they were in years past. And so, with that, they're expecting their employers to comply more than they have before as well. And so, what does that mean for you as employers, HR professionals? It means that you need to stay on top of things more than you ever needed to before, because the chances of liability are greater. And so with that, let's talk about those legislative updates. So the first statute that I want to discuss is the Working for Workers 5 Act. So this is a bill, oddly named bill, if you ask me. But it's the fifth in a series of legislation over these past few years. So the Ford government, just 3 or 4 years ago, they tabled what was at the time called the Working for Workers Act. They've then continued that series, and so now they've actually made it to 6. Spoiler alert! I'll talk about that in a moment. But earlier this year, they tabled the fifth of these bills. And so, these are statutes that are intended to make changes to a variety of employment-related laws. And as the name suggests, in many cases, they are, kind of employee-friendly changes. Sometimes the changes are, they seem more significant on their face than in reality. In some cases, they don't really change the law all that significantly. In other cases, they do, and they create new rights and entitlements for employees, and with rights and entitlements for employees come obligations for employers. And so, it's important for you to understand these. I'm going to speak first here about the Working for Workers 5 Act, and in doing so, I'm going to talk a little bit about the Working for Workers 4 Act as well. So the Working for Workers 4 Act, that was tabled last year, but it came into law this year. And then certain aspects of it are going to come into law in the future, like I'll talk about. The Working for Workers 5 Act, that one was tabled earlier this year by the legislature. They spent a few months this year, reviewing that legislation before they passed that into law just over a month ago. So right at the end of October, this one became law. Again, there's certain aspects of it that will not actually become effective for a little while yet. I'll talk about that. But broadly, this legislation now has become law. And so there are a lot of aspects to that. There's changes to the Employment Standards Act, the Occupational Health and Safety Act, the Workplace Safety and Insurance Act, which is the legislation that governs the WSIB and Workers' Compensation Scheme in Ontario. I'm not going to talk about all those changes. I'm going to talk about the biggest ones to the Employment Standards Act and Occupational Health and Safety Act, given time constraints and what's going to be most important for all of you. So first of all, for employers that have 25 or more employees, they're going to be required to include in every public job posting. So this is not internal postings, but public, external postings. They're going to have to include a statement about whether the job posting is for an existing vacancy or not, subject to certain restrictions that may be to come. In addition to that, employers are also going to be required to, for any applicant who's actually interviewed, let that applicant know if there were other interviews conducted, and then also ultimately whether a hiring decision has been made. And so both of those, are there other interviews, and then has a hiring decision been made? Those will have to be notified to everyone who's been interviewed within 45 days. Now, these two changes are not yet in force, just to be clear. Although, like I said, the legislation broadly has become law, these changes are not coming into effect until January 1st of 2026. That's actually hot off the press. As of last week and even earlier this week, we didn't know when these changes were going to come into effect, but the government has just introduced that information, and it's going to be Jan 1 a year from now. So a year and whatever it is, 3 weeks. I can't believe we're into December. So you've got a little bit of time to prepare for this one, but as I think we all know, the years pass quickly, and you'll need to make sure that you're getting ready for these changes so that come 2026, your job postings will be compliant. And by that same date, January 1st of 2026, there are some other changes that, like I mentioned before, come from the Working for Workers 4 Act that became law earlier this year and was tabled last year, and some other changes there that impact job postings that will also come into effect on that same day of January 1st, 2026. And so those are that the job postings are also going to need to include ranges for compensation or the compensation amount if it's set for the role that's being hired for. And you'll also need to disclose whether you use AI to screen applicants or select applicants as part of that hiring process. So that's, again, just a couple of the changes that will be coming into effect. In addition to that, the Working for Workers 5 Act has a prohibition on sick notes. This one got a lot of media attention, so this might be one that you have come across already. But this one is a prohibition on sick notes specifically to validate sick days in line with those sick days under the Employment Standards Act. So as some of you may know, the Employment Standards Act currently provides for 3 unpaid sick days for employees. Just about all employees. There are certain very limited exceptions, but generally all employees. So every single year, employees are entitled to at least 3 unpaid sick days under the Employment Standards Act. Many employers provide more than that, and many employers provide some or all of the days paid, but that's the that's the floor, that's the bare minimum in the ESA. And so as it relates to those minimum 3 unpaid days, employers will now no longer be able to request sick notes to prove the employee's entitlement to those days. This is a change that's, being done kind of for a couple of reasons. We started hearing a lot of noise about this during COVID, when it was prohibited to ask for sick notes to prove entitlement to the COVID days that, that were kind of job protected leave days that were introduced earlier in the pandemic. With that, we heard a lot of attention about it. Doctors really, really like this because doctors are, I think, we've all heard of the media attention on this. They're overworked, underfunded. They don't have the capacity they feel to be doing sick notes for employers, even when the employer, pays a little bit for those as is typical. And so, the more and more prohibitions on these, the better when you ask doctors. And it also, of course, is being done for societal reasons to keep people who are sick at home and not make others sick where possible. Now, with that said, this is not all encompassing. So in many cases, employers don't ask for a sick note for those first 3 days of the year, or even for the first 3 days of one sick period, even if they've already been sick earlier that year as well. A lot of employers don't ask until a little later. Maybe someone's been off for a week and now there's no idea when they might be coming back. Sometimes it's more at that kind of a stage where employers start thinking, I better ask for a note here. And if they've been off for more than 3 days that year, in my reading of the legislation, you would still be entitled to ask for the sick notes because this prohibition is tied specifically to those 3 days in the ESA. It remains to be seen how the law will keep changing on this, particularly in light of another change that we're now going to see from the Working for Workers 6 Act that I'll talk about. But as it stands right now, in my view, this is really going to have limited application to employers. Just be careful not to ask for a sick note for those first 3 days of the year. If you're asking for a sick note that sets out an employee's, medical limitations for the purposes of accommodating them when they get back, even for those first 3 days, I think that's probably okay. Again, this remains to be seen in the law, but on my reading, I think it's likely still reasonable as long as you're very clear that you're not asking for proof that they were sick for those 3 days, but rather information to help you accommodate them when they do come back. And then again, after those 3 days, it's much more likely that you'll have broader discretion as an employer to request those sick notes. So the other changes that I want to talk about from the Working for Workers 5 Act relate to the Occupational Health and Safety Act. And so there are two changes that are somewhat related. And these are two of those ones that I was kind of saying before. They sound bigger than they really are, in my view. So the first is that the Occupational Health and Safety Act's requirements for employers, they've been somewhat expanded now. So before this, there was an argument to be made that where employees were working from home, the Occupational Health and Safety Act didn't apply. So the broad obligation for employers is to take every reasonable precaution for the protection of workers to protect their health and safety. That arguably may not have applied before to employees working from home. That's not the case now. And again, that was arguable in the first place. Now the Occupational Health and Safety Act will apply to employers when their employees are working at home. And so, what does that mean? You need to make sure that they're going to be safe. Some of the things you might want to do as an example would be, to make sure that you do some sort of check for their workplace at home. Maybe it's, you have them give you like a virtual tour with their camera of their workspace to identify any hazards, cords in the way that might be a tripping hazard, or electronic issues that could create some potential, kind of fire safety issues, what have you, to take a look at things like that. Some employers might not go to those lengths. Some may ask their employees, for example, to sign some sort of attestation that, they've done certain things to make sure the workplace is safe. There's various ways to go about this, whether what you've done is going to be enough to meet that requirement to protect your workers ultimately probably won't actually be assessed until someone gets hurt. But you want to get ahead of this, and you want to try to avoid those injuries, of course, for lots of good reasons. For the employee's own benefit, for your own operations, productivity, what have you. So in addition to that, the change that I would say is probably less significant, even though it's got a lot of attention, is that the definition of harassment in the Occupational Health and Safety Act, it's being expanded now to expressly include virtual harassment. So as it stands right now, harassment is going to be defined as any vexatious comment or conduct against a worker where it's a course of comment or conduct. And so, that's the kind of the broad definition. That definition in most cases is going to be, interpreted to essentially mean what you probably are thinking more casually about what harassment is. Oftentimes it's going to be similar, and if not the exact same as bullying. But that definition, it didn't speak to whether or not the conduct had to be virtual or in person or not. It was just, a course of comment or conduct. Now, expressly, that course of comment or conduct will, that could be harassment, will include where that's happening virtually, online, by text, what have you. Again, in my view, probably the definition already included virtual harassment anyway, but now there's no question. Now it does include virtual harassment. And so, when you're thinking about that as an employer, you want to understand, what is that going to mean for you? Well, Like I mentioned briefly at the outset, one of the obligations under the Occupational Health and Safety Act is that you have to investigate workplace harassment allegations and incidents. So, as an employer in Ontario, you have an obligation if you become aware of a potential incident of harassment, whether because someone actually made a complaint or just you heard it through the grapevine or you observed it yourself or what have you, even if they didn't make a complaint, you have an obligation to investigate. And there's certain requirements as part of that obligation that I won't get into now, there's certain specific requirements that you have to meet as an employer and some pretty significant penalties if you don't comply with them. It's now abundantly clear that even if that conduct is virtual, you're still going to have those same obligations to investigate. Again, that's just an example. The obligations across the board are going to apply when it comes to virtual harassment, but that's going to be the most important one is you need to make sure that you're investigating. Going to spend a little more time on the legislative updates here because, like I said, this is a big year for legislative updates. So I mentioned the Working for Workers 5 Act was tabled earlier this year, was passed into law at the end of October. And that was just a few months after the Working for Workers 4 Act was also passed into law. Now, just a few weeks later, the government has introduced the Working for Workers 6 Act about a week ago now. And so that legislation, once again, is changing a whole bunch of different, or is intended to change a whole bunch of different statutes in Ontario, um, including the Employment Standards Act and Occupational Health and Safety Act. And again, the Workplace Safety and Insurance Act is there as well, but I'm not going to speak about those given time. In this one, what are the changes that you should expect? And I should say, I'm saying expect because, like I say, it's just been tabled. It's got to go through the legislative process, and then actually become law. Because the Ford government still has a majority, we should expect that it's going to become law. That's been the case for all these other Working for Workers acts and really most legislation that the government tables these days. When they have a majority, they've got the votes to pass it into law. And so really it's probably just a matter of time. Not definitively, it can change still. And sometimes, significant lobbying efforts can change, it can lead to changes in these bills before they become law. But usually, what's tabled is going to become the law. And so, it's more likely a matter of when as opposed to if these come into effect, but there's a bit of an if there still as well. So when you're thinking about this one, what are the most important things that you're going to have to know? Well, one is that parental leave entitlements will likely be expanded. And so now employees who become parents via surrogacy or adoption, they're going to be entitled to an unpaid parental leave of up to 16 weeks. To be eligible for that, they would need at least 3 months of service, and they must provide at least 2 weeks of written notice of the intent to take the leave. But they're going to be entitled to just shy of 14 months, 16 weeks of leave in those cases. Like with other parental leave entitlements that exists already for birth parents, what have you, employers do have the right to request reasonable evidence to verify the employee's eligibility. In practice, I would say most employers don't request that kind of proof. Usually employers will kind of accept that an employee is going to be having a baby because it's pretty clear that it's in fact happening, but you do have the right to request that evidence if it's necessary to. In addition to that, there's also going to be a potential new entitlement for long-term illness leave. So if you didn't know about it before, when you heard me just talking about the 3 unpaid days of sick leave under the ESA, you may have wondered, that doesn't sound like a lot, right? Don't employees take longer leaves otherwise? And, oftentimes they do. And, typically where an employee has to take sick leave for longer than those 3 days, the employer still has a duty, not under the Employment Standards Act to protect their job and bring them back, but under the Human Rights Code, because you have a duty under the Human Rights Code to accommodate disabilities. And that's not limited to certain durations of time, the way that the ESA sick leave is limited. Now, so those obligations are, in many cases still going to be there anyway, but the ESA brings, very kind of concrete clarity to it. And only 3 days. There's been a lot of lobbying over the years that's really not enough. And so what we're seeing now is the government's responding to those arguments, and they've introduced a new unpaid long-term illness leave for employees. And so that would be a leave of up to 27 weeks for employees who have a serious medical condition, leaving them unable to perform the duties of their job. Again, they would need to have the same 3 months of service to be eligible for this one, although like I mentioned, even if they don't have that, those human rights obligations might kick in anyway. So, keep that in mind. And again, you would be entitled to get a certificate from a medical practitioner to prove the entitlement for the long-term illness leave right now. So this is different as it stands, as it's been tabled from the 3 unpaid sick days, which you aren't entitled to ask for a sick note for. For this long-term illness leave, as it's been tabled right now, you are entitled you will be entitled to ask for a certificate. Now, will that change? You never know. I would expect that we'll see lobbying efforts from employee groups, unions, what have you, to say that employers shouldn't be allowed to get sick notes for this long-term leave either. But that remains to be seen as it stands. That doesn't appear to be currently the government's intention. And the last one that I want to talk about is one of the various Occupational Health and Safety Act changes in the Working for Workers 6 Act. And that will be that employers will be required to ensure that PPE, so personal protective equipment, clothing, whatever it might be that's required in your workplace. Of course, that depends on the workplace, masks sometimes, helmets, steel-toed shoes, etc. Employers will be required to ensure that that equipment is properly fitted for all employees. And so, if your practice has been for the PPE in your workplace, if you have any, to just kind of get one size fits all and just pass it out and expect that's enough, it may no longer be enough where, an employee has a need for something that's, more fitted toward them. So, that could bring some more costs and certainly more work for you to do as an employer. All right. And I think Angelica said it at the outset, but I'll just note, please do feel free to add your questions into the Q&A box that you should have available there. And I'll make sure I get to them at the end. But I always encourage attendees, drop those questions in as we go because we're covering a lot, and sometimes you might forget that question if you wait until the end. So feel free to drop it there, and I'll make sure I get to them at the end. All right. Next development that I want to talk about, like I said, I wish I didn't have to keep talking about this year over year when I do these, year in review discussions, but yet another year with, yet more big changes. I need to be talking about it for you because it's really important for you to understand. So, just to level set for all of us, and for those of you who know this already, I'll try to be quick, but for those who don't know, I want to make sure you understand the context. In Ontario, like in, like the rest of the country, you have an obligation by default if you let an employee go without just cause. So without, very good reason, very few things, amount to just cause these days. So in most cases, when you let someone go, whether it's because of their performance or their conduct or, just because you don't have the work for them or what have you, you have an obligation to provide them with what the courts term to be common law reasonable notice of dismissal or pay in lieu of that notice. Very high level, what that means is that there's a default rule that if you're going to let somebody go, you have to give them a certain amount of notice. The amount of notice is not a specific formula because the courts don't like making it easy on us. Instead, it's a variety of factors, and then there's a contextual analysis that the courts would actually go into to determine what that notice period would be if you don't provide it. So basically, no one really knows until you let the person go, and the person doesn't think they got enough notice. Then they have to sue in wrongful dismissal that goes to court, and then the court tells you at the end of that, well, here's what the notice period should have been. And so that sounds difficult. The reality is, we can get a good idea of what the courts will likely award based on, what they've awarded in other similar cases. But the general idea that the courts follow is the employee should get enough notice to be able to give them time to get another job. And so what enough is in any case will depend on how long they've been employed, how senior their role is. So the longer they work, the longer the notice period. The more senior they are, the longer the notice period, because the idea is there are fewer, senior jobs out there and they're entitled to try to find something comparable. And then the older they are, the longer the notice period as well. Typically, it's at least a couple months, can go as high as a couple of years or more. That's the default. Along with that, there's a default under the Employment Standards Act for employment termination pay and severance pay. That's typically quite a bit shorter. It's a week per year of termination pay, roughly up to 8 weeks, and then another week per year of severance pay for larger employers and longer service employees, up to another 6 months on top of that. But that caps out at 8 months. Compare that to the common law, up to 2 years or more. It's much longer in that case. And so because the common law is so much longer and because, paying up to 2 years of pay in lieu of notice or giving 2 years of actual notice is often, really challenging for especially smaller businesses, employers have an interest in trying to reduce that. They can't reduce it below what the Employment Standards Act requires. That's the floor, and you can never contract out of the Employment Standards Act as an employer, but you can, with your employees, contract out of the common law obligations. And the way you do that is through termination clauses in the employment contract. And so a termination clause is something that spells out, if the employee is let go without cause, here's what they're going to get at termination. These are the clauses that have led to a lot of cases over the last 15 years or so in Ontario's courts. Frequently what the courts do is they kind of change the way that they're interpreting these clauses. And so something that previously would have been found to be enforceable based on the state of the law then, the courts will now say, oh, for this other reason that we didn't think about before, this one is no longer going to be considered enforceable. And so because the courts have shown a willingness to really, accept these very technical, in many cases, in my view, personal opinion, unreasonable, arguments to say the termination clauses are not enforceable. It's really incentivizing employees and employee side lawyers to make new creative arguments to say these clauses shouldn't be enforced either. And so because of that, there's a constant, push and pull where something, a termination clause is drafted, it's put into a contract, it seems to be enforceable based on the state of the law at the time. But a couple of years later, there's another decision and it says that a clause like that is no longer enforceable. And so this has been happening now again, kind of the pendulum's been swinging for about 15 years. You may recall if you were there with me a couple of years ago when I did one of these year in review presentations. In 2020, there was a huge case, a case called Waxdale from the Ontario Court of Appeal. And at that time, I would say the vast majority of termination clauses that were in effect before that in Ontario were like that, no longer enforceable because of this change in the law. This year we had the biggest development like that since Waxdale. This one I would say is not quite as significant, but many termination clauses that were enforceable at the beginning of this year currently would no longer be considered to be enforceable because of another new case this year. And so that's where I really want to focus today. So that case is a case called Dufaux and the Corporation of the Township of Ignace. So in that one, early this year, I think it was in February or March, the Ontario Superior Court struck down a termination clause because in that case, the termination clause said the employee would, at dismissal, get only the Employment Standards Act minimum entitlements, which is pretty typical language. But it said that the employer had the right to let the person go without cause at any time and for any reason. Now, language like that has been very common in a lot of termination clauses. Again, check yours if you haven't yet. You might have that language, you might have an issue. That language is not intended to really mean the employer can do it any time, but it's really just intended to make it clear to the employee that generally, the employer has that right to let somebody go without cause, which is the general state of the law anyway in non-unionized environments. The court in this case said, and the language like that, by the way, has been before our courts many times. The courts have never taken issue with it before, but this time the employee argued, well, hold on, doesn't that mean that the employer could fire the employee because they've taken a job protected leave under the ESA, which is forbidden by the ESA, by the way? And the court said, oh yeah, it does say that. So for that reason, we're going to say this clause is no longer enforceable. And so as soon as the court said that, similar clauses for that other employers might have would similarly likely be found to be unenforceable. And we've already seen a couple of other cases follow this one already this year. And so, what does that mean? If your termination clauses suggest that you have the right to dismiss somebody at any time or for any reason, or if any other clauses in your employment contracts or potentially your policies suggest that you have that same right to let somebody go for any reason or at any time, even if it's not in the kind of standard termination clause part of the contract, you might have a problem. And so, you should be getting that legally reviewed. That case has been appealed. It's actually tomorrow that the Court of Appeals is going to be hearing that appeal. So hopefully we'll see a change to that. I frankly would not get my hopes up. The courts have really been moving in a increasingly employee-friendly manner to really take these technical reasons to strike down these clauses. So I would expect, if I were to bet that they're probably going to uphold this decision, unfortunately. And so, it behooves you as employers to, make sure you take a look at those termination clauses. And, if you have language like that, speak to a lawyer, get them updated, and speak to a lawyer about how to roll out the changes to your employment contracts too, because that's a tricky process that you'll need advice on. But make sure you're taking a look at that, or else, you're facing that potential common law notice entitlement, which is, like I said, very, very significant if you do have to let somebody go. It's not all bad news, I will say. There was another decision a few months ago called Birch, and in that case, the court actually did enforce a termination clause. It didn't have the same kind of language that the Dufault case did, but it was another clause that fairly simply tried to say the employee, when they're let go, will get whatever the Employment Standards Act requires. And in that case, the court did uphold the clause. That was, a good sign, because again, the courts are frequently finding new reasons to strike these down. But it's a good reminder, if it's properly drafted, properly put into effect, you've done it with legal advice, then you've got a good shot at your termination clauses being enforced. And so it is worthwhile as an employer to make sure that you have them regularly reviewed, update them where necessary, and ensure that you can rely on them if it turns out that you need to, because the employee's done something that's fireable, or business changes occur and you need to let someone go. Next up, bad faith conduct. And I'm going to try to go through my last couple of sections here a little bit more quickly, because I know we're running out of time already with how many legislative changes we have. I'll say when I started planning this webinar a couple of weeks ago, I didn't intend to spend the time on the Working for Workers 6 Act, or quite as much time on the Working for Workers 5 Act, but big changes again in the last week or so there. And so I had to spend a bit of extra time compared to what I intended. So when we're talking about bad faith conduct, what we generally are referring to in employment law is conduct at the time of termination that would lead a court to say, this was not really fair to the employee. And so along with whatever their termination entitlements are legally, entitlements definitely under the Employment Standards Act, potentially under the common law or the contract, depending on whether the termination clause is enforceable, the employee is going to get all of that. But on top of that, the employer is going to have to pay them something more because they treated the employee unfairly. And so, in years past, the courts have really had a high threshold for these additional damages to be awarded. The damages that we're talking about, colloquially, we refer to them as bad faith damages. In kind of legal parlance, what we're referring to is aggravated damages or punitive damages. There's other kind of similar damages where an employee's human rights are violated, then that's discrimination damages as well that I'm not really talking about, but they're related. Those can also result in more money to the employee at termination. But when we're talking about bad faith, it's aggravated punitive damages. And so the courts used to really say, only the most egregious conduct is going to result in bad faith damages. The bar has been getting lower. Unfortunately, it's another kind of piece of bad news if you're an employer. Good news if you're an employee. The bar has been getting lower and lower these past 3 or 4 years, to the point that really, conduct that I think most reasonable people would say doesn't seem like that big of a deal, is now resulting in, bad faith damages as well. For example, we've seen a few cases now where an employer, in some cases seemingly innocently, just forgot to issue the record of employment as quickly as they are required to. You have a very short turnaround time legally to do that after you let someone go. The employer forgot to do that for a little while, and that has resulted in, thousands of dollars in extra bad faith damages to the employee. That does have significant impact on the employee. It can delay their EI eligibility, and obviously that's important for people who have been let go. But, if the employer misses it by a short period of time and it was a mistake, should the employer really be digging that way? The employee will get that kind of back EI anyway. I would say maybe that's not, a reasonable thing, but that's where we are now legally. And so, you need to be mindful, that bar is getting lower. And so, it just means that as an employer, you need to be even more careful than before to, treat the employee as fairly as possible and not misstep in these, ways that may not seem like that big of a deal on their face in order to avoid these extra damages. And so there were two big cases this year that were kind of relevant. One came out of British Columbia. That's Klin and Pentax, the first one that I have there. In that case, the employer had a termination clause in the contract, and it provided for the employee's legal entitlements at termination. And on the wording of the clause, it would be enforceable. So it would, properly restrict the employee's entitlements to what the contract said. In that case, though, the employer, rather than just paying out what the employee was entitled to under the termination clause when they let the person go, which is what the contract required, the employer actually withheld that money. And they required the employee to sign a release before they would pay out those termination entitlements to the employee. So a release is a full and final release. You've probably heard of these. These are documents that employers typically have employees sign when they give them something extra in exchange for for receiving that extra money, and that's typically in order to stop the employee from being able to sue the employer in future. So in that case, the employee was required to sign to say, I won't sue you, and then they would get their entitlements that they already were entitled to based on their contract. They said, I'm not going to sign that. Instead they sued. And in that case, the court said this clause would have been enforceable, this termination clause, but because employer, you required the employee to sign away their rights for something they were already entitled to, you repudiated that contract. We're not going to let you rely on that contract anymore. It would be unfair to kind of hold the employee to that contract when you didn't comply with it yourself. And so the employee's entitlements are not limited anymore to just what the employment contract says. Instead, they're entitled to common law reasonable notice. And like I was saying, that's typically a lot more. And the employee was entitled to an additional $25,000 in bad faith damages. Now, you might think, that seems unfair. The employer shouldn't do that. And certainly doing that intentionally, yeah, that's unfair. Maybe that should result in bad faith damages. I will say I've had a number of clients over the years, by mistake, write a termination letter that, isn't intended to require the employee to sign off to get their minimums, but rather only to sign off to get extra. But based on the language, it wasn't really properly worded. Really, there was an interpretation that it would say the employee had to sign to get their entitlements. And in a case like that, we might be seeing the same kind of extra damages. And so you need to be careful that, those termination letters are kind of properly drafted to avoid that kind of liability. On top of that, there was another case, Koshman Control X. In this case, the founder and president of a company passed away, and the company then was passed into his wife's control. His wife became the president. And then when the wife took over as president, she made a whole bunch of changes. She went around actually telling people that one of the VPs of the company, who had a lot of power in that company, they she made some pretty strong comments about them. She actually was telling people that that the VP was involved in her husband's murder, that the VP was no good, was a nobody, was dishonest. She was telling people that the VP took kickbacks. She told clients to deal with her, not with that VP. She, directed that VP's direct reports directly, going over the VP's head. And so in that case, the VP sued, and ultimately the employee was awarded an extra $100,000 in damages because of these improper remarks and conduct that the new president made. By the way, the court found that those comments were not factual, in case you were wondering. And so the employee got significant termination penalties plus an extra $100,000. And so again, a good reminder, make sure that you're going to be careful, when letting somebody go, and don't misstep. Don't say something that's even if you're kind of offended by the employee, they've done something that's really inappropriate, a fireable offense. If you go overboard and kind of telling other people negative things and potentially negatively impacting their reputation, you can face huge damages like that employer did. Next up is workplace investigations. So I don't want to spend a lot of time on this one, but as I said before, when it comes to harassment allegations, employers have a statutory obligation to investigate under the Occupational Health and Safety Act. Employers more broadly have kind of common law legal obligations. So this isn't set out in legislation necessarily, but according to the courts, they have an obligation to investigate other types of allegations of misconduct or wrongdoing. For example, if you were to let somebody go for cause because you think they did something wrong, if you don't first investigate that, give them a chance to respond to what you believe may have happened before you let them go, you may face some bad faith damages, for example. And so, investigations are becoming a bigger and bigger part of employment law, and more and more important for employers to understand that and make sure that things are investigated before you take significant steps. So, there's a question, what do I have to investigate, right? A lot of times people are working from home or employees have friendships, relationships outside of work. What if there's some harassment, for example, that might come up in that context? Does the employer have an obligation to investigate there? Is that relevant to work, or is that off duty and the employer should leave it alone because it's not their business? There was a case this year that really helped bring some guidance to that. And it was a case involving Metrolinx. It was an arbitration decision. This involved a unionized workplace. And so in this case, there were a group of Metrolinx employees who had a WhatsApp group chat, and they made sexist, derogatory remarks about another employee as part of that group chat. It wasn't a work mandated or permitted group chat. It was just something that these employees who knew each other from work, had together on their personal phones. But in this case, the employer found out about these comments, kind of through the grapevine, and they investigated, and they ended up actually firing these employees because of the kind of, egregious nature of these comments. The union, on behalf of those employees, grieved, and they said this wasn't work related. This had nothing to do with work, so the employer had no business getting involved in this. And the arbitrator actually agreed. They said, yeah, this was not work related. The employer shouldn't have fired them. The arbitrator reinstated those employees in response to that grievance. But then the employer took it to the court, and the Ontario Superior Court, they agreed with the employer. They said, in this case, the employer actually had an obligation to investigate, regardless of whether there's a formal complaint that's been made, regardless of whether the conduct may have originated outside of work. In this case, because it impacted the workplace, because, the employee who was being talked about kind of found out, what have you, the employer's duty to investigate under the Occupational Health and Safety Act was triggered. And so the employer had to investigate. That was their statutory duty in this case, because they have that duty not only to the employee who makes the complaint, but to all of their employees where something might impact the workplace. And so, in this case, the court said this was an incident of workplace sexual harassment. The employer had a duty to investigate, and it was proper for them to dismiss the employees based on those findings. And so, this is just another good reminder as an employer. Not everything that seems like it's probably outside of work is really outside of work. This is a concept that comes up in workers' compensation as well. Something that might seem not really work related sometimes is considered work related, and where someone gets hurt doing it, they're entitled to WSIB benefits. And so, as an employer, don't take it at face value. If something seems like it might not be work related, really assess and maybe consider getting legal advice if you're not sure, to determine whether you have, obligations that you need to follow to deal with that conduct. Last but not least, I want to touch on human rights and accommodation. So in this one, I'm just going to speak really quickly here because we are low on time, and I see there are a few questions popping up already. Um, so when you're thinking about accommodation as an employer, it's hard. You need to balance the employee's needs, and most employers, most managers, most HR professionals, you care about your employees. You want your employees to get the opportunities that others have if they need accommodation. You want to make sure that you're giving them what they're entitled to. It's very rare that employers are intentionally failing to accommodate people, but employers aren't only thinking about their employee, they have a duty to the business to think about the business as well, or the organization as well. And you have to think about, what are the operational needs as well? You're paying these employees to get a certain job done, and there's duties. Sometimes there's funding that's tied to the employee doing their job. Sometimes the company needs to think about the bottom line and their other employees as well, because accommodating employees can impact others who have to take on and take on more work and pick up the slack and what have you. You need to balance these things, and it's a hard thing to balance. When you're considering that, what you need to do as an employer is really understand that both parties have an obligation. So if an employee wants an accommodation because they have some sort of disability, the employer has a duty to ask questions, get the medical information that's relevant in many cases, not information about the diagnosis, but what limitations the employee has. And they need to then actually offer a reasonable accommodation to that employee that would allow them to engage in the work effectively, having regard to those limitations that they have. The employee has an obligation too. They have a duty to cooperate in that accommodation process. And so we had a case this year involving a Dairy Queen franchise up north that really helped, stress that point. In that case, there was an employee who went on leave. She took leave for a little while. The employer accommodated. They protected her job. She came back to work for a few months. They brought her back. And then all of a sudden, one day she just went back off work and wouldn't respond to the employer while they were asking some questions. And then, kind of out of the blue, it seemed to the employer a little bit later, she filed a human rights application and said that she wasn't properly accommodated. And in that case, the Human Rights Tribunal, they looked at it and they said, well, in this case, she got the accommodations when she was entitled to it. When she said she was sick and needed time off, she got it. And then, after she went off work again, she wasn't cooperating with the employer, saying, here are certain things that I need. She just, she didn't play her part. And so in that case, the employer was found not to have failed to accommodate that employee. And again, that stresses the point that employees have a job to do too. If you're asking them for medical information that's relevant and narrow enough, you're not asking them for too much, and it's only things that you need to accommodate, and they're not cooperating. Well, that could, that changes the calculus, and you may not have to keep accommodating depending on the circumstances. So you want to make sure that you understand what your employee has to do as well. And then there was another case called Aguele this year. In that one, it involved a situation where an employee wanted a specific accommodation and the employer did not provide that. They provided something different that worked better for the operation. And so the employee had a preferred accommodation that they expected. They didn't get that. They got something else that reasonably accommodated them, but was not what they really wanted. And again, they brought a human rights claim. And in that case, again, the adjudicator said, no, the employer only has to provide a reasonable accommodation to the employee, not the employee's preferred accommodation if there's something else that's reasonable and works better for the operation. And so in that case, again, the employer did not fail to accommodate. And again, good reminder, consider what's best for the business, for the organization as well. And that is relevant to take into account as long as the ultimate accommodation is reasonable for the employee's disability. All right, so we're again low on time here. There are some other developments. I'm not going to spend time here. What I will say with respect to those other developments, take a look at my firm's blog. We blog weekly, including about everything that we're talking about here. We also put out a couple of newsletters every year, including a year in review newsletter. My team is actually back at the office finalizing that as we speak, and so I'm going to do my best to share that with everybody. Along with the slides and try to put a link in here so you can download it. But if that isn't quite ready by the time I'm sending the slides out, then I'll ask Angelica if it's possible to send that around. Note also that my office is going to do a much more intensive, longer webinar. Some of the same content's going to be covered, so it would be redundant a little bit, but we'll get into some more detail. We'll cover some of these other developments as well in a few weeks. And so if you're interested, please reach out to me and we can get you on the list and make sure you're invited. With that, our Fast and Furious year in review comes to its end, and it's time for some questions.